The $250,000 inheritance trap. Let's sit down and kill the 4 big lies that quietly cost families 6 figures every single year. Lie number 1 is the classic advice to just add a kid to your deed so you can skip probate. It sounds so simple and helpful, but when you add a child as a co-owner, you often accidentally turn part of your home into a lifetime gift. That move completely kills the step-up in basis on the portion you gave away, which is just a fancy way of saying you locked in your old, low purchase price for them. If you bought your place for $100,000 and it's worth $600,000 when you pass away, a clean step-up means your kids can sell it with almost no tax bill at all. But if you gifted it or used the wrong joint title, they could end up owing the IRS taxes on hundreds of thousands of dollars in gains. That fast fix everyone talks about usually turns into a very slow bleed for your family's bank account. Now, here is where most people really mess things up, because joint tenancy with a child is not the same thing as joint tenancy with a spouse. When you own a home with a spouse in many states, you can get a full or even a double step-up in basis, but you usually don't get that same break with a child. You are also handing your kid a whole bunch of new risks, since their creditors, divorces, and lawsuits now have a legal hook in your house. You didn't actually save yourself from probate, you just gave up control of your own front door. Lie number 2 is that you should gift the house now so Medicaid can't take it later. The 5-year look-back rule says otherwise, and any gifts you make inside that 60-month window can trigger a penalty period where Medicaid won't pay a dime. This means you could be stuck paying for care out of your own pocket, right when your costs are at their highest. And yes, that gift also wrecks the step-up in basis we just talked about. So you solved absolutely nothing and created 2 brand new problems. You've delayed your benefits and guaranteed a massive tax bill for later, which is the exact opposite of what we want. Lie number 3 is the idea that a simple will is enough to protect your family. A will is really just a ticket to probate court, and it is definitely not a way to get around the system. Probate adds a ton of time and expensive fees to the process. Plus, it makes all of your private family business a matter of public record. While the court drags its feet, the markets move, the house needs expensive upkeep, and your heirs get more stressed out by the day. A revocable living trust, if you set it up correctly, lets you stay fully in control while you're alive and passes everything to your family privately and much faster. Here is the shortcut that nobody ever teaches you. The trust preserves that tax-saving step-up because you didn't actually gift anything during your life, you just changed the name on the title to your own trust. Lie number 4 is that a transfer on death deed or a beneficiary form fixes everything on its own. These forms can help you avoid probate for one specific asset, but they don't do anything to fix your cost basis. If you set them up the wrong way, they can foul up your timing, split ownership in weird ways, or clash with the rest of your estate plan. I see people all the time with a TOD on their house, different beneficiaries on their bank accounts, and a will that says something else entirely. The result is always the same. Family fights, long delays, and sometimes a forced home sale just to cover taxes that never should have existed in the first place. Before we go any further, you really need to understand this big lever called the step-up in basis. Think of it like a total price reset that happens the moment you pass away. If you do it right, all that lifetime gain on your home can just vanish for tax purposes, and your kids get a clean slate. If you do it wrong by gifting the house, adding a kid to the title, or using casual TOD forms, you freeze in that low original price and hand your family a giant tax bill the second they try to sell. The stakes here are very real, and I've seen heirs end up selling the family home just to have enough cash to pay the IRS. You can also lose control of your life because if you add a kid to the title, you might need their legal signature just to refinance your own home or get a line of credit. If they get sued for a car accident, your roof is suddenly in the crosshairs of a lawyer. None of this happens with a properly drafted, revocable living trust where you stay the boss as the trustee. for as long as you're alive. Let me show you exactly how one single piece of paper flips that huge tax hit down to near zero. You title the home into your revocable living trust, keep your primary residence status, keep your control, and keep that step up in basis intact for your heirs. You should pair that with clean beneficiary designations on your retirement accounts, but those usually shouldn't name the trust unless an expert tells you to, because those tax rules are a bit different. Finally, you add a pour-over will to catch any stray assets and funnel them right back into the trust. It's simple, it's clean, and it's completely private. The reason this whole system works so well is that you aren't actually giving anything away while you're still here. You are just getting organized, which helps you avoid the 5-year Medicaid gift penalty and the basis trap while skipping over all those probate delays. If you live in a state with strict property tax rules, we can handle that timing with the right exclusion forms, so your heirs don't get slammed with higher taxes every year. We are going to cover exactly how to do that next. Step up in basis, super simple. If you don't remember anything else from today, I want you to remember this. The step up in basis is a price reset that can erase decades of taxable gains. The thing most people miss is that it only works if your ownership is set up the right way at the time of death. Gifting your home while you're still alive or casually adding a child to the title can block that reset and lock in your old, low purchase price forever. Here is the simple version of how it works. Your basis is just your starting line for taxes. So if you bought a house for $100,000 and spent $20,000 on a new roof, your basis is now $120,000. If that home is worth $600,000 when you pass away, a proper step-up lifts that basis all the way to the fair market value on that day. When your heir goes to sell the house for $600,000, there is little or no taxable gain for them to worry about. That is exactly why wealthy families do not gift their homes during their lifetime, because they know that the reset is where you actually win. Now, there are 3 main places where people usually lose this benefit. First is the lifetime gift, because handing the deed to your child right now gives them your old, low basis with no chance for a reset later. Second is using the wrong joint titles with your kids, because joint ownership with a right of survivorship can act like a partial gift. You might only get a partial step up in that case, and your child's share will keep that low original basis. Third is using sloppy transfer on death deeds without looking at your overall plan. A Todd might pass the title along, but if you split the ownership or mess up the timing, you can create a reporting nightmare and miss out on your best planning chances. The one shortcut nobody ever teaches is that you must avoid lifetime gifts if you want that tax reset. So, how do you actually keep this benefit for your family? You start by titling the home into your revocable living trust while you are still healthy and active. You still own the house, you still control every part of it, and you still get your homeowner exemptions if you want to sell or refinance. You didn't give the house away as a gift. You just organized it for the future. When the time comes, the trust passes the home to your heirs, and they get that beautiful step up in basis. If you live in a community property state, make sure your trust and deed reflect that, because that is how couples can get a double step up. This happens once when the first spouse passes, and again when the second one does, though it always depends on your specific state rules. Even if you aren't in one of those states, you still protect that reset by avoiding gifts and keeping everything clean through your trust. Another place where people trip up is when they let their kids move in without putting anything on paper. Having a child live with you is perfectly fine, but you shouldn't mix that up with side deals like promising to add them to the title if they help pay the bills. That kind of move blurs the ownership, clouds the tax basis, and is basically an open invitation for family fights later on. Keep any caregiving agreements in writing as a separate thing, and leave the deed safely inside the trust. Let me show you exactly how to spot these risks in your own life today. I want you to make a quick list of your assets, including your home, any rentals, your brokerage accounts, and your retirement funds. Next to each item, write down what it's worth now and what the likely gain is since you bought it. If an asset has a big gain attached to it, put a big star next to it and label it as reset needed. Now, go ahead and make a do not gift list using those starred assets, because that one list alone can save you from a six-figure mistake. Remember that retirement accounts work under different rules and don't get a step up the same way. So keep those beneficiaries current and usually name real people instead of the trust. There are a few common mistakes you should try to avoid right this second. Don't rush out and get a TOD deed for your home without checking your local property tax rules first. In some parts of the country, a transfer can trigger a huge tax reassessment unless you claim an exclusion on time, and those deadlines really matter. Also, don't just assume your will controls everything you own, because any assets with beneficiary designations will pass outside of that will. You need to make sure your titles and your beneficiary forms all match your main plan, so the step-up lands exactly where it should. Here is your quick win for the day. In the next 20 minutes, I want you to start that asset list, circle your home, and write the words, "Keep step up, no lifetime gifts." Then, make a plan to call a qualified estate planning attorney this week and say one very clear sentence to them. Tell them, "I want a revocable living trust that preserves my step up in basis, avoids probate, and aligns with my state property tax rules." Once you nail that one thing down, everything else starts to click into place. You get to keep control of your life now. Your heirs get a much cleaner reset later, and that $250,000 tax bomb just disappears. Estate playbook to keep control. Let's build a simple playbook that keeps you in the driver's seat right now and sets your family up for a smooth ride later. Trust me, having a plan in place feels a lot better than just hoping for the best, and it's way easier than you might think. You'll want to start with a revocable living trust, which you can think of as a special box that holds your stuff while you keep the only key. Since you are the trustee while you're alive, you can sell the house, refinance the mortgage, or change your mind whenever you want because nothing is locked in yet. The big win here is that your family avoids the nightmare of probate court, and you keep that valuable step up in basis. Since you didn't actually give the house away, you just moved it into your own box. When the time comes, your successor trustee just follows your instructions quietly and quickly, which is much better than a judge doing it slowly and in front of the whole world. You should pair that trust with something called a pour-over, to act as your ultimate safety net. If you accidentally leave a small bank account or a car outside of the trust, this will basically says, "Hey, scoop that up and pour it into the trust where it belongs." This keeps things simple, so there is no guessing or family bickering, and everything flows exactly where you wanted it to go in the first place. Now, you have to actually update the deed, so your home is titled in the name of the trust, which is the one step almost everyone forgets to do. If that deed never moves, the trust is just an empty box that can't do its job. But please don't try to help by adding your kids to the deed as joint tenants. That is the big trap we talked about earlier, where you end up with gift tax issues, lose your tax basis, and suddenly your kids' creditors can try to take a piece of your roof. Keep your title clean by making sure the trust owns it while you stay in total control of the property. Next up is your beneficiary audit. And this is where you need to look at every single account you own. Retirement accounts like IRAs and 401(k)s usually need to name actual people as beneficiaries instead of the trust, unless your financial advisor gives you a very specific reason to do otherwise. The tax rules for inherited retirement money are a bit tricky because there is no classic step-up, and the IRS usually puts your heirs on a 10-year clock to take the money out. If you get this part wrong, you could trigger some nasty penalties or a giant tax bill, so make sure your bank and brokerage accounts match your overall plan. You can use transfer on death or TOD forms for smaller things, but be very careful about slapping one on your house without checking your local property tax rules first. In many states with parent-child exclusions, your heirs have to file specific paperwork incredibly fast after you pass away to stop the county from hiking up your property taxes. If they miss that filing or mess up the instructions, your family could end up paying thousands of extra dollars every single year for no reason. Your trust documents should include very clear language about who is supposed to claim those rights and exactly how to get it done on time. We also need to talk about Medicaid timing, because that 5-year look-back rule is the real deal. If you give your house away within 60 months of needing care, Medicaid might refuse to pay for your help right when you need it the most. If you are thinking about life estates or other fancy moves, please go talk to a real elder law attorney who knows the rules in your specific state. Don't try to wing this one, because a poorly timed gift can ruin your benefits and your tax breaks all at the same time. Some of the biggest traps are hidden in those helpful forms the bank asks you to sign. You might have an old form naming an ex-spouse as a beneficiary, or a title mistake that accidentally turns community property into separate property, which can kill the double step-up for married couples. This is just boring paperwork, but it costs real money if you ignore it, so try to do a quick 1-hour sweep of your accounts once a year. Read the exact names on your titles and confirm your beneficiaries are still who you want them to be, so you can fix any mistakes before they turn into family fights. I promised you a half-page clause that saves money, and here it is: property tax instructions. Ask your lawyer to add a section that tells your trustee exactly how to file for parent-child transfers and how to claim any senior or homeowner exemptions that are available. This tiny little paragraph is what prevents that "oops, we forgot" moment that ends up raising the tax bill for the next 20 years. Heirs often move too slowly because they are grieving, but the tax man doesn't wait for anyone. The clock starts ticking the moment someone passes away, and those forms are often due within just a few months. You should put those due dates on a shared family calendar right now and pick a backup person who can handle the paperwork if your first choice is too busy or overwhelmed. Go ahead and pre-fill the names, parcel numbers, and contact info today, because your future self is going to be so happy you did. Here are your action steps for this week to get everything moving. First, call an estate attorney and tell them you want a revocable living trust that protects your step-up in basis and includes property tax instructions. Second, get your deed, your mortgage statement, and your last tax bill together along with a list of every account you own. Third, make sure you actually move the home into the trust by recording the deed instead of just signing the papers and putting them in a drawer. Fourth, clean up those beneficiaries so your retirement accounts name the right people and your other assets align with the trust. Finally, get your pour-over will and healthcare directives updated so someone you trust can make decisions if you aren't able to. Once you get these pieces in place, everything else just clicks into gear. You stay in charge while you're healthy, you avoid the Medicaid gifting traps, and you make sure your heirs aren't forced to sell the family home just to pay a tax bill. With that property tax clause and a calendar, you've basically eliminated the chance of a surprise tax hike. Nobody is asking you to go to law school or become an expert on the tax code. You are just putting all your assets on the same map, so everyone knows where to go. It's like being a good pilot who uses a checklist instead of trying to be a hero. Stay independent, enjoy your life to the fullest, and let the paperwork do the heavy lifting so you can focus on the fun stuff. Property tax reset trap. Now, let's talk about that sneaky bill that shows up every single year.